what I would encourage you to do as Anna's presenting is throw us some questions. And if you don't ask any questions, I'm going to ask you to give questions. And if you still don't give us any questions, I'm going to still ask you for some questions. So I'm going to annoy you in the audience as much as possible to give us questions. Why? Because I think with this type of material, a good Q&A is going to be more beneficial to you than us just talking. How do you research Tennessee law on appreciation of separate property? Two good ways. One, Janet Richards has a great book called Tennessee Family Law. I don't have it right in front of me, but that's usually our first stop. The second stop, you've got this materials, and most of this materials I'm probably going to have on my website. I've got a blog, Tennessee Family Law blog on memphisdivorce.com, and in there I've got a subcategory called property classification. This is a classification is it marital or is it separate? And the topic we got is a subtopic called appreciation of separate property. So these cases will be on my website with a summary and a link to those cases. Does Tennessee use alimony in Solido currently? Yes, they do. Yeah. So, and if you want to look up alimony in Solido on my website, I've got a lot of discussion on it. And I've got a separate alimony category. So you see alimony in Solido either to even out marital property or to pay out in a lump sum of what might otherwise be a future stream of payments for alimony. My clients often ask me to offer alimony in Solido in lieu of monthly payments just because they don't want to make monthly payment checks. And money now is always better than money later. So that's again another great area for the forensic accountant to advise the divorce attorney on how much alimony in Solido should we offer to buy the person out of either a transitional or alimony in futuro claim. Assuming you're calculating a separate property interest, say a 401k from date of marriage to divorce, to date of divorce, and you're missing brokerage statements for the first 5 years of marriage due to their document retention policy. We're going to take out document retention policy because, people.
And they have no retention policy. They just threw them away.
Yeah. How can we fill that in that gap with proof? Do you want to start with your answer, Ann?
Heck no. I mean, we'd start discovery, but we got to, what if they just threw them away? You answer that, Mom.
Right. So if we're talking about a 401k, we are likely talking about, and again, thank you, Rob, because I know you know the answer to this already.
That's why we hire Rob.
Yeah. The underlying assets, if there are, let's say it's straightforward. Again, we got a 3-fund portfolio because it's going through an employer. We can research as best we can what were the dividends and pricing back to the date of the marriage. Now, if we don't know the balance of the account at the date of marriage, and we don't know how, or obviously we don't have the number of shares owned at the date of the marriage, that does create a problem because you got zero proof. Now, this is where it gets really fun, guys. It's fun with a capital F. Can you get away with guessing? All right. Do we have some tax returns? Do we have some old, with those tax returns, do we have some W-2s that we might be able to fudge and figure out? Do we have, does the employer maintain old 401k summaries for all employees? All right. I was reminded the other day of a story. I used to work for another divorce lawyer, and they had a 401k, and I contributed to it. but I didn't have that much money in it. So I left it in there just to annoy the other attorney, knowing that he'd have to see my name on the 401k statement annually. It was a little something fun, but it wasn't enough money to worry with one way or the other. But the point is, there may be documents somewhere, and then if you can't, then you just guess. Because don't forget, evidence can be a statement by a party. So if a party says, I had, and I remember at the date of marriage back in 1990, I had $53,000 in my 401k among these three mutual funds. And I still have those same mutual funds today. So it's a proof problem that just because you don't have the documents doesn't mean you can't duct tape a solution to it. And who decides what is enough to carry your burden of proof? A trial judge who, odds are, either has a political science or English major in undergrad. So that's my answer to it. You duct tape it, you do the best you can with it. At the last resort, you estimate. But issue subpoenas everywhere. As you know, I like to say subpoenas are the duct tape of the divorce lawyer's world. You can do a lot with duct tape, and you can do a lot with a subpoena. And just because it's over 7 years doesn't mean you can't go get it. Hopefully that was helpful. And then finally, the question from Richard on business valuations. Have you been successful in overcoming the oath line on a mortgage loan application? If so, what steps did you take? Now, I know what Rob is typing in advance already. And what Rob is talking about is one of his old cases. And you can direct message or email Rob for that. The business owner had put down on a loan application from a credit facility that the businesses were worth $3.3 million. All right. And so the Court of Appeals said that the statement under oath was made under the criminal penalty of perjury, which all applications are. But we also had a recent Court of Appeals case, and that one went up. Mitch Moskowitz's client argued that the real estate appraisals put on a mortgage or a loan application to a bank were not reliable enough to set actual values for divorce. Court of Appeals, actually I may have had that backwards, but the Court of Appeals said and remanded back to the trial court saying that the trial court could not rely in that case on statements on a loan application when there were no real estate appraisals.